Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for steno dictation. This dictation is for the aspirants who are preparing for JW exam. Be ready. Shri S. K. Mehta, Learned Counsel for the Society, contends that in this case both the parties had taken up inconsistent stands at different stages of the litigation, and in that state of affairs, the courts below should have ignored the past conduct of both the parties and gone by the contents of the documents of title in order to decide the matter. Stop. The courts have held the conduct of the society in some of the prior litigation, but when it came to a consideration of the like conduct on the part of the plaintiff, they have chosen to make light of it, accepting the same excuses put forward on his behalf. Stop. We shall therefore consider the impact, if any, of the earlier proceedings in this case on the question at issue. Stop. The detailed narration of facts set out earlier will show that the parties have not been consistent in their stands and have tried to blow hot or cold as the occasion suited them. Stop. Taking up the stand of the society. First, the society, in its application to the custodian for reduction of rent, claimed successfully that what was allotted to it was only a plot of land, and that the small shed thereon had been put up by the society itself. Stop. So also in its application for allotment dated 21/1/1957 and 15/10/1960, it referred to the property only as an industrial plot. Stop. The letters addressed by the Society to the Custodian and Settlement Commissioner, as well as the application for reduction of rent and the order thereon, are valuable pieces of evidence, both because they are anterior to the litigation between these two parties and also because they reflect the representations of the society and the findings of the very authority that allotted the property to the society. Stop. The society represented that it had been allotted only a plot of land and that the shed had been put up thereon by itself, and this plea would not have been accepted by the custodian. Stop para. Shri Mehta tried to argue that the custodian has only reduced the rent on general grounds and has given no finding that only a plot had been allotted to the society, but we are unable to accept this contention, as both in the opening sentences as well as in the body of order there is a clear finding to this effect. Stop. This is a very strong circumstance to show that what was allotted to the society was only a plot of land. Stop. Secondly, the findings of the rent controller in the application under section 44 filed by the society, right or wrong, have attained finality as between the parties, and it is not open to the society on principles analogous to res judicata to take a contrary stand in these proceedings. Stop. It is true that in the suit for injunction filed in 1964, as well as in its application under Section 44 of the Rent Control Act, the society took up a contrary position and claimed that the property was tenanted premises. Stop para. It is not clear why the society filed the suit if the property was subject to the Rent Control Act, and though it appears that the plaintiff pointed out that the property was the subject of proceedings under the Rent Control Act, the suit was eventually dismissed without any finding. Stop. Again, the society's claim in the second set of proceedings was rejected by the rent controller in a reasoned order on 9/3/1972. Stop. The statement of Ajit Singh is ambiguous, as it says that on the one hand that there was a shed, but also says on the other that what was allotted to the society was only an open plot. Stop. These are therefore not of much help to the society. Stop. Turning next to the stand of the plaintiff soon after acquiring the property, he applied to the rent controller, though unsuccessfully, or the eviction of the society on the allegation that the property comprised a shed, that it had been unauthorizedly sublet, and that the plaintiff required it for reconstruction as residential premises. Stop para. Shri Ashok Tiwari, learned senior counsel appearing for the appellants, fairly stated that this court may not interfere with the direction given by the learned single judge of the High Court, which has been confirmed by the division bench, because in compliance thereof the Northern Regional Committee has already granted recognition to the private respondents, and by now they must have admitted students against the sanctioned intake. Stop. He, however, argued that the reasons assigned by the learned single judge for striking down the cutoff date specified in clause 5 of Regulation 5 are legally untenable, and to that extent the order of the learned single judge and the judgment of the division bench are liable to be set aside. Stop. Learned senior counsel emphasized that the cut-off dates have been prescribed for submission of application to the regional committee and communication of the decision regarding grant or refusal of recognition, with a view to ensure that decision on the issue of recognition of the colleges is not unduly delayed, and the students admitted in the recognized institutions are able to fulfill the requirement of attending at least 180 teaching days during the academic session. Stop. Para. Learned senior counsel further submitted that the cut-off dates specified in clauses 4 and 5 of Regulation 5 have direct nexus with the object of ensuring time-bound decision of the applications submitted for grant of recognition, so that the teaching and training courses are completed by every institution well before commencement of the examination, and the candidates who fulfill the requirement of attending minimum classes and training courses are able to take examinations. Stop. Shri Tiwari then submitted that the 2007 regulations contain a comprehensive mechanism for grant of recognition to eligible applicants for starting courses and for increasing the intake, and the provision for consultation with the concerned state government, union territory administration has been made with a view to ensure that unduly large number of institutions are not granted permission to start the courses, and the state may find it impossible to provide employment to the students successfully completing the courses every year. Stop para. Learned senior counsel made a pointed reference to letter dated 27/1/2009 sent by Principal Secretary of the Council to the Regional Director, Northern Regional Committee, on the question of grant of recognition for B.Ed courses in the state of Rajasthan for academic season 2009-10, to show that decision was taken by the council not to grant recognition, keeping in view the fact that there was virtually no requirement of trained teachers in the state. Stop. In the light of the above discussion, we hold that the cut-off dates specified in clauses 4 and 5 of Regulation 5 of the 2007 regulations, as also the amendment made in Regulation 5 wide notification dated 1/7/2008, are not violative of Article 14 of the Constitution, and the learned single judge and the division bench of the High Court were not right in recording a contrary finding qua the date specified in notification dated 1/7/2008. Stop stanza. We further hold that the provisions contained in Section 14 and the regulations framed for grant of recognition, including the requirement of recommendation of the state government, union territory administration are mandatory, and an institution is not entitled to recognition unless it fulfills the conditions specified in various clauses of the regulations. Stop. The Council is directed to ensure that in future no institution is granted recognition unless it fulfills the conditions. Stop.